Well, this article was written to analyze a bunch of literature that has emerged recently regarding digital governance or the governance of the digital. Under the name Digital Constitutionalism, many things are conceived, explained, proposed, criticized in what is currently going on in the legal regulation of technologies. So my aim was to explore that discourse much more than to explore the technology itself or the positive law that applies to technology itself. So basically, I wanted to study a cultural artifact, which is the transfer of the grammar of contemporary constitutionalism from the state to another space, the digital space. The discourse about digital constitutionalism comes from various places. For example, when you are a state and you want to regulate social networks or what is going on the internet, you have to apply your positive law, including constitutional law. So this is a first version or a first perspective on digital constitutionalism. The other trend that comes from the private sphere is that those spheres have been given some autonomy, precisely because, according to their own constitutional law, some states hadn't any right to regulate the internet because of freedom of expression. So this led to more autonomy for private actors, and they developed, according to some authors like Günther Teubner, for example, a constitutionalization of their own self-organization. Basically, contemporary constitutionalism is based on the idea that constitutions are rational documents enacted by a people, a sovereign, in order to protect two things: separation of powers and fundamental rights, and the global aim being limiting power. Whereas in the sphere of digital law, we observe that there is sometimes a confusion between the three main functions that are traditionally identified in a state. Terms of use define the legislation in the digital sphere. The social network, for example, enforces those terms of use, and then if someone is not happy and criticizes or appeals against the decision, a content moderation decision, for example, then the private power will adjudicate, so that the very same entity is at the same time establishing the rules, enforcing the rules, and adjudicating in case there is a difficulty in the enforcement of these rules. And what is crucial and what explains the use of the constitutional vernacular is the fact that these decisions, these regulations, are not about unimportant things. They are about fundamental rights, traditional fundamental rights like freedom of expression, non-discrimination, human dignity, etc. So here, there is a tension between the ambition to constitutionalize those social spaces because they involve our traditional fundamental rights, and the fact that they are, by their very structure, by their very constitution, in another sense of the term, they are at odds fundamentally with the ambition to limit public or private power. This oversight board is relevant precisely because one of its ambitions, according to Mark Zuckerberg, was to make it a Supreme Court of the internet. So this is a very clear example where one actor, and one of the leading actors of the sector, borrows directly from the concepts of traditional constitutional law and the enforcement of the supreme law of the land, as it is called in the United States, in order to conceive, in order to imagine the institutional structure of a social network, the institutional structure of the digital sphere. So here we have a very clear example of a direct transfer from one space to another.